Well, welcome everyone to today's webinar on antitrust remedies. My name is Clark Casey. I'm a professor of law at BYU, and this is part of BYU Law's Future of Antitrust series. I'm really excited today to have three wonderful guests with me to discuss the future of antitrust remedies and some of the current things happening with antitrust remedies and cases. So let me briefly introduce the three of them. Obviously, I'm not going to be able to capture everything about them. Check them out if you don't already know them online and find out more about all the really interesting, fascinating things they do. So George Contreras is the James T. Jensen Endowed Professor of Law at the University of Utah, where he researches intellectual property, standardization, and antitrust law. He serves on the advisory board of the American Antitrust Institute and is a member of the American Law Institute. Is prolific with his scholarship, and we're really thrilled to have George with us today. Hal Singer is an economist specializing in antitrust, consumer protection, and regulation. He has testified and published widely on competition issues across industries such as media, pharmaceuticals, and finance. Dr. Singer is Managing Director of Econ One, Professor of Economics at the University of Utah, and Director of the Utah Project, which focuses on antitrust and consumer protection. Thrilled also to have you with us today, Hal. And then Erica Douglas is an Associate Professor at Temple University Beasley School of Law, also specializing in antitrust, data privacy, and intellectual property with a focus on new technologies. She previously practiced antitrust and tech law at Covington and Burling, LLP in Silicon Valley, and we're thrilled to have Professor Douglas with us today. So thank you for being here, both our distinguished panelists as well as everyone joining the webinar. So we're just going to jump right into the content and discuss antitrust remedies. So antitrust law obviously has been a hot topic for a while now. Number of high-profile cases that were filed against big tech companies and others during the first Trump administration, as well as during the Biden administration. And now some of those cases have resulted in government victories and have moved into the remedies phase. And in particular, Google has been sort of at the forefront of some of these cases, been found liable for antitrust violations, both with respect to monopolizing the online search market and online advertising, which is, they're very related, obviously. And so a remedies decision on the search case is expected by August. In that search case, the DOJ is seeking a number of remedies, including divestiture of the Chrome browser, data licensing and sharing arrangements, and then foreclosing exclusive arrangements with the likes of Apple and Mozilla, in which those companies agree they receive large payments from Google in exchange for making Google search the default search engine in their respective browsers. So the first question to the panelists, which of these proposed remedies do you think show promise, and which do you think might not be the best of ideas? Anyone want to lead us off on that?
I think George wants to go first. Yes?
George always wants to go first, yes.
Well, thanks, Hal, for cold calling me. And I'm happy to go first. So just a little bit of level setting for the audience, right? I mean, there are three categories of remedies that are available in antitrust cases. And they're rather different, so we're all familiar with monetary remedies, which exist in cases across the board, not, however, in enforcement cases brought by the agencies in this country. The agency authority to seek remedies under the Sherman Act and the FTC Act is largely limited to injunctive relief of one kind or another. Monetary remedies only apply really when it's a criminal prosecution or in private enforcement antitrust suits, which obviously we're going to see and are coming down the pike later. So we've got two choices: the structural remedies, the types of things that Clark described as divestiture of a business unit, and behavioral remedies, right, which are enjoining the offensive conduct. And the other important thing to remember about remedies in enforcement actions brought by the agencies in these cases is that they can only act prospectively. They are only intended to prevent further anti-competitive harm from occurring and not intended to punish or redress injury from previous harm. So they've got to be forward-looking. And so to get to the point, in the search decision that came out late last year, it was Google's distribution agreements that were found to be anti-competitive. The agreements in which browser companies were required because they were paid by Google to preload Google search in their browsers and to exclude preloading other companies' browsers or other companies' search into their browsers. Those agreements were found to be anti-competitive for a number of reasons and violative of the Sherman Act. I mean, my view from a remedies standpoint is a fairly parsimonious one. If that's the harm, then I think the remedy should match the harm, in that these agreements should be declared unenforceable. They should be amended, reformed by the court so that the anti-competitive provisions are removed and neutralized. And I think they're fairly significant financial deals. So it's not like this is a minor remedy, but in my view, the structural remedies that the Department of Justice is pursuing are significantly more expansive and encompassing than they would need to be to address the actual harm that the court found in this case.
I think we're going to spend a lot of time sort of criticizing the remedies, which is fair. But before we dive too far into it, I think it might be reasonable to recognize that designing these sorts of monopolization conduct remedies is probably one of the most difficult tasks for antitrust enforcers today. There's all these analogies that I always get used to, like wild animals, when it comes to designing these remedies, like shoeing a galloping horse, or Tom Barnett said it's like once you catch a tiger by a tail, what do you do with it? And so I think I agree with a lot of what George's framing is, but I think it's also just difficult to figure them out. And I think that's kind of overarching for all of what we're talking about today. And I think, Clark, really your question goes a lot to what the government is trying to do with these remedies. Like, what are the goals of antitrust remedies? And there, I think I might frame a little bit broader than what we've said so far. I think it's ending the unlawful conduct. And I think that's really what the termination of those default agreements is. But I think the more challenging part of the remedial design is restoring competition to the market, kind of prying open these markets to competition in the way that we've always tried to do, sort of from United Shoe back in 1968 to the 2001 Microsoft case. And that is very forward-looking and very difficult to do. And I think that's part of where some of the most challenging areas are for this sort of design. But I tend to come down on the proposed divestitures also being one of the most challenging. You said bad, I think, Clark, but I don't know if they're bad, but I think it's probably one of the most difficult areas, because from a practical perspective, it requires a qualified buyer, right? A lot of funding and bravado. And AI companies and Yahoo have said they might be buyers. But even if they buy, I think there are other questions, and we've had past experiences, at least in the merger context, where the divestiture doesn't lead to a successful competitor in the marketplace. So that goal of prying open to competition isn't really achieved. So do you see how I went from don't criticize too much, it's hard, to criticizing immediately? I think that's probably what they're going to get a lot of these sorts of remedies discussions.
Yeah, great.
So I'll weigh in, and maybe I'll try to defend the divestiture. But before I do, let me just say, disclose at the top, that I'm the expert in two active cases right now against Google, not in the search cases, but one is a private ad tech case. Another one is the private Play Store case in the UK. So with that, I think that each of the three that Clark teed up at the top, show promise. And I think it's important to go back and recall, and you mentioned this, Erica, but I'll just say it again, that the purpose of a remedy per the Microsoft decision, and I think international assault, is to not only stop Google as unlawful conduct, but also to deny Google the fruits or insult, the consequences of its past conduct. And that's the harder part. And we also want to restore competition among search platforms. And that would allow, for example, other parties, counterparties like publishers, to extract better terms for granting access and allowing the scraping of their content. Right now, they're only really dealing with one behemoth. If they could play two search engines off each other, they might be able to extract better terms. Now, the three that you mentioned, Clark, I think the divestiture of Chrome is actually the cleanest, in the sense that it would require the least amount of resources to police and enforce on a going forward basis, certainly with respect to, as compared to, say, the data sharing and syndication remedy, which I guess we'll talk about later. But everyone should know Chrome is part of the GMS bundle, alongside other must-have apps like YouTube and Google Maps. And you really can't split apart that bundle. The OEM can't split apart. It's kind of an all-or-nothing package that Google offers. And so as a result, they've gotten everyone to carry Chrome, and Chrome, hence the search, Google Search, has become the default search on every Android device sold in the United States. So the DOJ's submissions, which I read before this, make a big deal about how Google is also planning to incorporate Gemini, its AI tool, into Chrome, and therefore give an artificial advantage to its own AI over those of rivals. And so the idea of, if Chrome were independently owned, it seems like it would be easier for search rivals, either current generation or the AI-based, next generation search rivals, to compete for access to the home pages of these handsets. I'll just mention quickly that with respect to the other two provisions, that require some oversight. The data access and syndication requires the most oversight. And I don't mean to suggest that because it requires oversight that it's a bad remedy. But I do want to flag that in an era where antitrust agencies are being squeezed in terms of resources, that remedy that requires a lot of policing may not be as effective as it is when you draw it up on the blackboard.
Great. Yeah, let's dig into a couple of these proposed remedies a bit more. One thing that I find really interesting about the divestiture of Chrome, I think Erica mentioned this, one of the potential buyers that has sort of come forward and said, yeah, we'd be interested in buying Chrome, is OpenAI, which is interesting because they are so quite a ways ahead. I saw a graphic recently in terms of monthly average users, or some statistic. It just shows they have such a lead in AI, and AI is increasingly sort of displacing search in certain respects. And so like that divestiture, a browser company, like a standalone browser company, probably doesn't really make a lot of sense. Like if there was a buyer that was this, like, okay, we're just going to run the browser and that's going to be our business, it would probably have to be someone like Yahoo or OpenAI. And does that just replace one monopolist with another? In the case of OpenAI, for instance. I don't know if anyone wants to, just an observation about that particular possible remedy.
Well, I think you're right that it wouldn't just be a browser. Right? The browser by itself isn't that valuable. What we're trying to do is instill competition among search engines. And you can have the old generation search engine, you mentioned Yahoo, or a next generation of the AI base. I don't think that you're going to get to the same place that Google got to, which is 100% penetration as the default on every Android device. I think if you open it up to competition and you allow for competition on the merits instead of this kind of artificial advantage that Google has enjoyed, then with luck, you would get some kind of split across the share. It wouldn't be 100% any longer. Ideally, you could have 2 or 3 different search engines, each with, say, a third of the marketplace.
Great.
Yeah, so I comment a little bit on the structural ideas. I mean, what you say and what Hal says and Clark, what you speculate might all be completely true. But it just strikes me as rather hubristic, right, for the Department of Justice and antitrust authorities in general to engage in this type of attempted engineering of a market um, based on nothing more than the liability findings in cases like this, right? So, we're all textualists now. So if you go back to the actual text of Section 4 of the Sherman Act that authorizes the department to bring these actions, right? They're authorized to institute proceedings in equity to prevent and restrain such violations. And the violations are violations of Section 1 and 2. And so, in every other area of the law, if a company violates the law, um, then that violation is addressed in as precise a way as possible, either with money damages, which aren't available here, or with some sort of injunctive relief. But in no other area of the law, other than antitrust, is the equitable relief so broad as we have possibilities of seeing here. And so, if a company's drug is harmful, we have it taken off the market, but we don't require the drug company to split up or affect the corporate structure of the entity. And so again, I just come back to the fact that the liability that was found here was really in the distribution agreement arrangements that Google had. And while all of these other improvements to the market and competition might be possible, it seems like these cases shouldn't be an open door to allow the regulators to attempt to engineer the market in these highly unpredictable ways.
Thank you. So on those agreements, George, maybe talk a little bit about those. I mean, one concern that I've heard articulated by, well, I mean, Apple and Mozilla obviously want the ongoing payments, like billions of dollars for Apple. I don't recall the number for Mozilla. And so, I mean, as I've heard some point out, well, you take away that arrangement for Mozilla, it's not going to kill Apple, but it might really harm Mozilla in a way that actually reduces competition, browser competition at least, because Mozilla is going to have a hard time without that inflow of income from Google, right? So I think that goes somewhat to your point, like no matter what we do here, we're not prophets. We don't quite know exactly how all this will play out. It's all just sort of speculating, but that's sort of the position we're in, right? That's what the judge, not we, but the judge has to sort of play that role.
Yeah, and it's just so what, right? So what? We're not trying to engineer the entire market here. We're just trying to prohibit a certain form of illegal conduct, right? You find, you know, selling drugs is illegal, right, in the United States. Well, okay, but now we're going to put a lot of drug dealers out of work and all sorts of other consequences are going to happen. Well, so what, right? The wrong that we're trying to address is the wrong that the remedy should address or should target. Anyway, I've said enough.
Yeah.
I think some
Erica,
of the problems with that is like how we frame what the liability finding was, right? So to me, if it's just the narrow framing of the agreements, then it tends to support your argument, George. But I think if we had DOJ sort of presenting it, it would be the flywheel theory of the violation, so that Google was obtaining this data by using those agreements, which gave it an advantage in search quality, which drove its revenues. I'm not saying I agree or disagree with that, but that kind of leads to the more interventionist remedies because each step in the flywheel is basically being addressed by a parameter of the remedies from DOJ. So I think that that tie between the liability theory and the remedy theory, it really depends on how you understand the liability theory of the case. But it's always going to be prediction and intervention into markets for these kinds of Section 2 cases, right? Like, and I think part of the challenge and why people are grappling with this so much is we don't have a bank of sort of like Section 2 remedies we can look to, right? I'm seeing a lot of people sort of draw on experience from merger remedies where divestitures have failed often. And so I think that that's part of why this is such a difficult enterprise. But I think that that liability remedy tie, we need to be cognizant of it when we're saying, you know, what the remedy should be.
Yeah, George, if I could weigh in, I just don't know if you're giving any weight, or maybe you just interpret these words differently than I'm interpreting them, or the Justice Department wants you to interpret them. But you know, when you look at the 4 objectives from the Microsoft decision, what we're trying to achieve, you seem to be glossing over deny the fruits of their prior bad acts, and you seem to be glossing over restore competition. But if you take those seriously, then we can't just enjoin Google from entering into exclusionary distribution agreements. We have to do more. And then Erica mentioned this point about, you know, if they achieve the scale advantages artificially, and as a result, you know, their product is better, you know, the algorithms are better, the ranking is better. You know, how do you ensure that going forward that search rivals can achieve the same scale, or at least be on par with and compete effectively with an incumbent who's derived its advantage in part artificially? These are really hard problems, and I think that's the purpose of the data sharing regime, is to kind of overcome that artificial scale advantage. There's a nice section in the, you know, one of the Google filings, I think it was the post-trial brief, but they're talking about how the data sharing would allow the rivals to achieve scale. And they talk about scale being used to understand both what to crawl and how to store that information in an index. Those are things that an advantage that Google got through scale. And the ranking algorithms also benefit from scale, I mentioned. And then, of course, the scale enables ads algorithms to select higher quality, more relevant ads to match search queries. I want to go back to just one thing real quick that Clark mentioned about Mozilla and Mozilla's harm, and you know, where does Mozilla's welfare rank in, you know, on our new welfare rankings? And I would just submit that, you know, if we're thinking about the parties that we want to restore, ultimately, I think are publishers. I mentioned at the top, we want publishers to get a better deal in their dealings with search engines who are using their content as an input into their product for free right now. And I think that we want to benefit advertisers, and that we want these, you know, the terms of the acquiring advertising, either in search advertising or third-party publishing site advertising, to be more generous to advertisers, and ultimately want consumers to benefit from having more competition on the merits for these products. There's these allegations that Google's search engine has deteriorated, at least by flooding with advertisements, and they may not have been able to get away with that had they been forced to compete on the merits. So I think those are the parties we're worried about. Mozilla's welfare, I don't know if they really enter, at least into if I was the social dictator, I don't know if Mozilla's welfare, God bless them, I don't know if they would enter very highly on my rankings.
Yeah. Goes back to George's point, I think, in part, that, you know, whatever remedy is instituted here, like, here's the harm, we remedy the harm, folks affected by that we can't sort of address in every instance. What about so we've talked about the divestiture some, the exclusive arrangements, the data syndication, or the data access and syndication, is, I think Hal mentioned earlier, that's the least clean, or the messiest possible remedy there. Do you want to talk more about that? I've also heard people say that, well, really there's only 3 or 4 companies that that have this sort of scale or the size to make use of that access. I don't know if I believe that, but I've heard people voice that. And again, it's going back to the, well, you're just, if you make this data, provide access to it, and the only people that are going to be able to make use of it are other very large companies that then just replace one monopolist with another. Just to throw that out there, I'm not saying yes or no, but I have heard people articulate that concern about that particular remedy.
Well, I mean, just because it's a big company doesn't mean it's a monopolist, right? I mean,
Right.
I think we'd be very happy with a market, or I would think the Department of Justice would be very happy in a market where there were like three big companies that were competing vigorously with each other, right? That's a good market. Just because, I mean, we won't have a lot of startups and so forth in the market. Maybe that's something that would even be better, but I think a well-functioning market could have just big players. You're not a monopolist just because you're big. And I would just also throw in, I'm not I'm not completely opposed to everything that Hal is saying. In fact, on the data part, I tend to agree. Right, that's not a structural remedy. I mean that's more of a behavioral remedy, and I think even though it's complicated, I think it could work, and I do agree with Hal. The Microsoft guidance that we have, you've got sort of fruit of the poison tree needs to be addressed, and this would be a good way to do it. But I point out that Microsoft itself, although it started as one, didn't end up having a structural remedy in the case, and so something like that may be where we end up here.
If I hear your question right, Clark, on sort of data syndication and resources to be able to use it to become a successful competitor, I think you're thinking sort of technological sophistication. I think part of it is brand too. I think brand is really compelling. We saw that mentioned as a barrier to entry in the liability stage of the case. And so if you're going to try to actually draw consumers to switch their default settings or to switch their browser and use some sort of competitor, I think brand building is going to be a big deal. And so then if we're talking divestiture, maybe a company that has an existing brand that's, I don't know, more trusted or known, like Yahoo might be more successful in doing that. But I think that we all keep coming back to Microsoft. Inevitably, it's sort of all we have as precedent. But I think that when we talk about the data remedies, there is a big difference. That's part of the other research that I do, which in the past, when antitrust was granting data access in cases like Microsoft, it was company data, it was the APIs. Now, some of this data is our personal information, right? There is a pretty big difference here, and that has made it more complicated to design this remedy. The initially proposed remedy really didn't say very much from DOJ on protecting users' privacy, as Google is handing over search information, ad information from individuals to these qualified competitors. And so I think that the personal nature of the data that's at stake this time has added sort of another outside consideration that some might put in the ambit of antitrust and some might put it, I think it's really more in the ambit of potentially unintended consequences of the remedy imposition. And so there's a lot of weight on the technical committee to make sure that data privacy is protected as qualified competitors receive this information. And I think there's a lot that we could talk about within whether that's going to be successful or not.
Right. Oh, great point. I think a cynical person might say, as long as it can't be any worse than being in Google's hands in terms of privacy, but I don't know that that's true. But I've heard people articulate that sort of response as well. But no, I think that's a really interesting, I think really valid concern to have. You start sharing all the consumers' information. We already have a pretty loose privacy laws in the U.S. Compared to other jurisdictions, and how we go about protecting consumer information privacy. And so that's if that remedy is administered, I think that has to be a big part of making sure it happens in an appropriate way.
Yeah, and I think who holds the data, to your point, sort of this narrative of like, well, Google has past privacy violations, and so another company having the information doesn't make any difference for privacy. I think that that's part of what's being overlooked in the remedy is the context of the data that the company has already about you. I'm talking about the qualified competitor who receives the information from Google, changes what they can know about you. Okay, data is contextual, so if they can cross-reference that data to something else, know more about you. It could be an AI company that's receiving it, right? If we're going to paint like the worry scenario. And so I think although we have light privacy laws from some perspectives in the United States, what's central to them is choice of the individual, and that's absent from all of these remedies because that would probably undermine them to a large extent. If you ask people, do you want to opt into giving your data to another company? They might say no, or they might not be able to get any response from individuals. So I think that there's a disconnect between the way that privacy law that we have works and the way that the remedy works, which is maybe all a sideshow to, if antitrust is more important and competition is more important and we trade privacy for competition, we can do that in policy, but I think it's a little bit latent in some of the discussions around this remedy.
Yeah,
And
that's
it's
great.
not necessarily a sort of a binary decision. And it's funny, I spent the first part of this week talking about these issues in the context of a different case that's gotten a lot of publicity, which is the 23andMe bankruptcy case, where there are huge concerns about the 15 million customers and what's going to happen to their data if a pharmaceutical company buys 23andMe's assets in bankruptcy. And there are a large number of protections and so forth that are being considered and put into place. A privacy ombudsman has been appointed by the court. There's a potential for a data privacy trustee to be appointed to be the one or put the data into some sort of a trust rather than give it directly to the company. And so there are a lot of very sophisticated mechanisms that are around that I agree. If this advances to the stage where data sharing becomes one of the remedies that the court authorizes, it might well look to what other courts are doing around the country in very similar contexts. I think there are enough ways to protect the data that the sharing can be done without endangering people's privacy too much.
Yeah, if I could just weigh in too, I think I agree there with George and Erica. I would submit that if what we're trying to do, for example, is make some rival search engine which has an add-on, search advertising capability, we want to make their ad algorithms do a better job in terms of matching up search queries to the ads that are the most relevant ads. It seems like we could give them a boost without disclosing the underlying user's identity, right? What they probably care about more is just general tendencies in the data. And so I feel like the data could be turned over in a de-anonymized fashion in such a way to help these rivals get up to speed on boosting their ad algorithms. So I'll just leave it at that.
Yeah, I think it depends on what information we're talking about. There's just a lot of different pieces of information that, if the proposed remedy, we're kind of assuming DOJ ends up being successful in sort of getting some sort of data remedy, but data obtained from interactions with a user's device and a search engine would be disclosed. So I think that some of the algorithmic sort of data or the aggregated data that you're talking about, Hal, it makes sense to not worry about privacy, but I think there's an incentive for ad targeting to want to know as much as you can about the individual that you're targeting it to. So I think there's sort of incentives to match information to find out more. And I think, George, you're absolutely right that the 23andMe is a nice analogy to the protections that could be put in place. They just aren't in this case. So there's a technical committee for this remedy, but the technical committee isn't required to have any privacy qualifications. It's not one of the qualifications in the list, right? There's something called information retrieval expertise, which kind of sounds like the opposite of privacy, I think. So I think that in the bankruptcy context, you have an expert in privacy overseeing the transfer of the data. And second, you also have limitations on what the recipient of the data can do with it. And this remedy is a little light on that. So does the recipient, the qualified competitor, agree to use limitations or deletion at a certain point in time, whether they can tell or not or connect or not? Those are good data privacy practices, and I think they make sense for when you're handing over user information to another company that the user has no relationship with necessarily.
Yeah. great. So we can come back to these remedies as needed as we continue to discuss sort of antitrust remedies more broadly. I want to switch gears a bit and just talk a bit about the Biden administration and the Jonathan Cantor-led DOJ and the Lena Khan FTC. Obviously, a sort of a new era of antitrust enforcement. The second Trump administration has showed, at least particularly initially, some continuity in terms of enforcement attitudes. I think we're starting to see some divergences. And so I'm just wondering what you all think. Again, we don't have a crystal ball, but just going forward, do we expect differences in the types of remedies the current Trump administration, the Trump DOJ and the FTC may pursue versus the previous Biden-appointed enforcers?
Who wants to go first?
Sorry. I was just going to say, I think we have some evidence that there are some divergences happening. We've had recently both the FTC and the DOJ on some merger clearances reached consent decrees that allowed, rather than injunction, they allowed the merger to go forward with some divestiture of assets. And so that seems to be one manifestation of a different approach. There's still antitrust enforcement. We're still going to be active, but maybe we're taking a different approach to the types of remedies we're going to pursue.
All right, I'll take it on.
Yeah, you're first, Hal. You cold called George, so you've got to go first this time.
All right. Well, man, maybe I can spice things up a bit by throwing some flames. But let me suggest there's some concern, at least among progressives, that Trump would be more willing to cut a deal with a party, either for private financial or political benefit. And so, for example, there has been speculation, at least in progressive circles, that Trump might ask the FTC to take a behavioral remedy in the Facebook case in return for Facebook, for example, agreeing to promote, certain right-wing propaganda on its website. And I would like to dismiss those concerns as being outlandish, but when I see some stuff coming out of the FTC of late, it does concern me that it could be acting for political reasons. I'll just give an example that Andrew Ferguson seems willing to carry out certain political orders, as evidenced by his launching of an investigation against Media Matters, what appears to be at the behest of Elon Musk, or by conditioning merger approval of two ad agencies on their commitment to advertise on Twitter. These are very unusual purposes for antitrust. They appear to be designed for explicitly political ends. The notion that they want to pursue advertisers for the possibility of engaging in a group boycott in their dealings with Twitter seems to be pretty far afield for what is traditionally done in antitrust. So for those reasons, I do think there's some fear that we could get some divergence. I think more at the FTC than at the DOJ. And I'll just point out that for an administration that prides itself on being deregulatory, the notion that they're ready to impose duties to deal on firms to deal with Twitter seems about as regulatory as you can get.
I think
Great.
We're already seeing some of what Clark and Hal you were talking about, which is under the Biden administration, we saw sort of a callback to previous eras of antitrust law where structure of the marketplace was more important. And that kind of goes hand in hand with structural remedies. And already in the Google search case around the AI ownership, there was a change under the previous administration's proposal to require divestiture of AI-related interests to now the current proposal softened to notification of future acquisitions that are related to AI. So a move away from structural remedies, I think. And I tend to agree with Hal's characterization. I think antitrust has always been political. I don't think the Biden administration, they still advance political goals through antitrust. But I think now we may find that what those political goals are is maybe stretched in a different direction, and some willingness to use antitrust to achieve policy goals other than competition and content moderation would definitely be at the top of my guess for that.
Yeah, I'm still at the edge of my seat, waiting a little bit to see what happens. So as you know, the area that I follow the most closely is patent law and the interface with antitrust. And in the first Trump administration, the DOJ Antitrust Division took an extremely activist role in patent cases, especially cases around standards essential patents, and delved into, I thought was actually acting ultra virus in many of its uh, amicus briefs and interventions in cases that had very little to do with antitrust law and more to do with patent law. That hasn't recurred yet in the second Trump Department of Justice. And I don't know why. I'm glad that it hasn't. You've got Elon Musk sort of counter narrative about patents are for the weak and we shouldn't care about patents. Certainly, let's not prop them up as an administration. And I don't profess to have any inside knowledge of what's going on, but I just haven't seen it yet. So this is one area where I hope that nothing really changes in a big way, and that interest is not taken as it was during the first Trump administration.
Yeah, the sort of regulatory versus non-regulatory thing is interesting because Hal and Erica, I think, and George, I think you're all sort of pointing to this tendency of sort of pick and choose in terms of when enforcement's going to happen and what remedies are coming and when it's not going to happen, and it's been somewhat hard to predict. I mean, I think with the Republicans, there's been a lot of interest. I think Erica's sort of alluding to this in terms of enforcement and remedies relating to content moderation because of perceived sort of discriminate, and this was what Hal was getting to with political ads and the like, sort of forcing Twitter into the mix. And so another way I think this manifests itself is what you might call and this goes back to our earlier AI discussions, or the national champions approach to industrial policy more generally. You've got Trump in recent months sort of chastising the Europeans for being too hard on tech companies, U.S. tech companies, and then, on the other hand, pursuing enforcement actions against U.S. tech companies. And so how do you think that dynamic in terms of regulate or not regulate will play out, like this national champion, like trying to promote national champions, particularly with respect to AI, right? We want to remain competitive in the AI space. And so that might affect whether the DOJ, FTC pursue actions, approve mergers, or whether they'll just sort of let some of these companies go unregulated in order to allow them to aggressively compete on the international stage. Any thoughts there?
Maybe I can add a little bit longer view. I think this has always been sort of the idea of national champions in policy has been debated in antitrust before. And the incident that I think about was around 2001. European competition authorities blocked the GE Honeywell merger despite US approval of it, and it sparked a lot of criticism of this being like a national champion protection. And that was before all of the tech debates, where the same sort of criticism has been levied at the EU. I think here we're asking, is the US going to start to do that? And I think when you think about the dichotomy between the two, I think it really preferring national champions is a displacement of antitrust policy. It's distorting competition in favor of other interests. And I think of it more as an issue around case selection than in remedies. A couple weeks ago, I would have told you executive discretion would probably be exercised to make Tesla a national champion. Now, no longer. The company I'd probably choose for that, I think a lot of the tech cases and tech companies we're talking about today are actually disfavored by the administration. But maybe the AI question is one. And there, I think we might see it play out in approval of buyers, right? Who can purchase these companies? It's going to be an American-owned entity. We've already seen in the national security context this play out for ownership of TikTok and DeepSeek and other companies like that. So I think that's the closest analogy that I see here.
Great, thank you.
I would say that this is certainly a possibility, but I would go back in history a little bit before 2001. I mean, this has been an issue since the inception of the antitrust laws in the 1890s. And there's a great quote from the Supreme Court's decision in U.S. Steel in 1920 that gets to this exact point. And the court was deciding whether or not there should be a structural remedy, whether U.S. Steel should be broken up. And they decided no for a number of unrelated reasons. But they say, we're unable to see that the public interest will be served by yielding to the government's argument about the dissolution of the company, blah, blah, blah. And we do see in a contrary conclusion, as if there were a structural remedy, if we broke up U.S. Steel, a risk of injury to the public interest, including a material disturbance of, and it may be a serious detriment to, the foreign trade. So explicitly taking into account the importance of the American steel industry in the global marketplace and not destroying our champion, U.S. Steel, so as to promote American competitiveness in the global market. And, no matter what we think about that, it's certainly not an unusual or a historical sentiment for the courts or for the agencies to be considering. I mean, I think it's an appropriate consideration.
And
sorry.
Sorry, go ahead, Hal. Go ahead.
I was just going to weigh in. I think respectfully that the national champions argument should have no role in antitrust determination. I think that every firm, every monopolist is going to claim that they're a national champion deserving of protection against some foreign rivals. And I just don't think it has any place in antitrust generally, or just remedy design in particular. I'll just note that some of the AI firms are using the national champions banner to seek immunity from state regulation right now, as we know, which I think is a bad idea. They're using national champions to secure subsidies from states to help them build data centers, which is also a bad economic idea. If anything, those data centers are raising energy bills for consumers and imposing negative externalities. We should be taxing them, not subsidizing them. But I feel like the national champions banner is just out of control in all regards and should have just no weight in antitrust considerations.
This may be impossible to answer, but going back to the Google search case, do we think it will? Or I mean, it sounds like, Hal, you don't think it should play a role at all in those remedies, but it could, right? And how might it manifest itself?
Well, I think the notion is that if we don't allow them to have 100% on the market, they're somehow going to be impaired in their ability to compete effectively against foreign rivals. But I think that even if their share were to drop to 50%, suppose we could design this market so that we get 2 search engines instead of 1. I think at 50%, they would still be of the requisite scale to compete effectively. I don't think that we should lose any sleep over the idea that they're going to become impaired at 50. in such a way that we have a chance of losing an industry to a Chinese rival.
Great.
We're talking about this too as though it's all sort of open for debate, but I think there's been criticism of whether it's within the agency's actual authority. Like, can they consider these things? So FTC Chairman Potofsky sort of said around the 90th anniversary celebrations for the FTC, like the national champion argument is a delusion. The FTC can't authorize, like, say, an anti-competitive merger because it advances national trade interests. That's not in the Clayton Act. So we think that we're framing it in a way that it might be framed that the agencies don't actually have this authority, because this administration is also criticizing agencies for acting outside of their authority and dissembling it in really significant ways.
Great. But it could be affecting sort of things on the back end, I guess, is one way to put it. I mean, I saw actually this morning that the Meta acquired Scale AI for billions and billions and more money than I have in my 401k, and I just is that being I think what I'm hearing from Erica and Hal is that when they're considering that sort of acquisition and clearing it, like they don't have authority to take into account, well, we want the US to be competitive on the AI landscape. This will help Meta they already have a lot of resources. They've sort of fallen behind in certain respects with respect to AI. This is going to help them bring them up to speed and provide yet another sort of US player. That's not within their authority is what I hear you two saying. And George, you're saying this has been there sort of all along. Like this has been something that's taken into account in how remedies might be structured. Yeah. Okay. So I want to ask the panel something about Meta. So we've talked about behavioral versus structural remedies. Meta is facing an antitrust suit where the remedies that are sort of being talked about are these structural, right? Like Meta acquired both Instagram, WhatsApp. It's been all over the news, right? These Zuckerberg emails about why they were acquiring these two entities. So like maybe that case as a good sort of jumping off point about structural remedies. Would those work in that case? And what are sort of, I mean, we've talked about the cleanliness, it being clean as one advantage of a structural remedy, but what are some of the possible pitfalls that we've seen in history and that might sort of resurface going forward?
I guess everyone's quiet now, so I'll say something. I think that the allegations in the Meta case are a closer fit to where we have traditionally seen antitrust willing to impose structural remedies. So acquisition rather than organic growth as the sort of central claim around the anti-competitive conduct. And so I think it poses a lot of the problems that we've thought about already for finding a qualified buyer and whether the acquisition is subsequently successful. So I always think of Safeway Albertsons, which is not tech at all, but they're a pretty qualified buyer. So an operator of about 100 grocery stores purchased the divested line of business and was still unsuccessful, and ended up selling those stores back to Albertsons. So how can we design for success? And I think we're talking about structural and behavioral as though they're separate. I think the behavioral can assist the structural, and that's probably going to happen if there's a divestiture in Google as well, but definitely in the Facebook case.
What kind of behavioral sort of remedies would you foresee there assisting the structural remedies of divestiture of WhatsApp and Instagram?
It'd be probably data related, right? So does there have to be, I think it's a little bit different because they're still operating as independent companies, right? And the egg is unscrambled. And so I think to that extent, but to whatever extent that there's crossover in what they know about users and data about users, when I post to Facebook, I still do because I'm old, it can also post to Instagram, stuff like that. So what does that mean for targeting of ads across the platforms and how does that drive value? I think that that's a data related thing, not a structural thing.
Great.
I just wanted to weigh in real quick with Eric. I don't know if you've seen this, but on the Albertsons failed divestiture, there's been speculation that it was designed by the merging parties to fail. That is the coalition of stores that were selected in that bundle. I think we're under bad performers or something. But I've gotten the sense that maybe that's not a fair one to judge divestitures on. But what's interesting, maybe I want to hear George weigh in here, because George, there the challenge conduct is in fact the acquisition. So unwinding the challenge conduct in that case would be a forced divestiture. Are you still opposed to divestiture, even in that case when the conduct is the acquisition?
Well, this case, I find it extremely strange, right? Because like these acquisitions happened over a decade ago, and Instagram happened in 2012. Like, how far back can we go? And the acquisitions were not opposed, or they were approved by the agencies at the time. And so I mean, yes, I understand. I mean, so structural remedies are more appropriate in the merger context. Usually the divestitures happen before as a condition to the approval of the merger. Um, a dozen years later, I don't know. That just to me that just seems like there should
Well,
the agency should have some sort of latches bar on the ability to bring these kind of claims. But in theory, yes,
okay.
yes, merger cases are the classic example where structural remedies make sense. This one I've got some serious questions about.
Okay, but in defense of the current or the con FTC brought the case. Oh no, sorry, actually it was Trump 1 who brought the case. Yes. There was a long period of time, George, in which there was almost no enforcement, particularly in the tech space, under the notion that it was a nascent industry and therefore we should defer and err on the side of leniency. And number two, it's possible that we just couldn't detect the way that the harm would manifest itself. I don't know if you followed that Facebook case closely, but the Hemphill, which is the FTC's expert, was put forward, I thought, fairly compelling evidence that Facebook was able to increase the ad load on users and do so in a discriminatory way that they may not have been able to do had they been forced to compete against WhatsApp and Instagram as independent competitors. I don't know if that could have been conceived at the time the merger was done. So I think that with the benefit of hindsight, maybe you detect harms that weren't knowable going in, and we should allow them another shot at the apple.
Well, it's tricky because if they're not knowable, I mean, one of the responses might be, well, the thing to do here is to apply more scrutiny at the front end, right? Because here what you did is you applied very little scrutiny, you let them sort of acquire these entities that even maybe at the time seemed sort of related businesses, and just let it sail through. And merger clearance traditionally in the U.S. hasn't been, I mean, it's been pretty smooth sailing, right? Not a lot of scrutiny being applied there. But if the harms are not knowable until like over a decade later, like how do you go about that? Is that like a solution in terms of remedies?
Anybody else want to go?
It's a question for George. That's why I'm keeping quiet. But I take your point, how these weren't ad-driven companies at the time. Like we didn't have the analytical frameworks in antitrust law to address that form of quality for free products, right? For a long time, there was this argument that because the products are free, antitrust law doesn't apply at all. So that's not right. And we've moved beyond that. But I do think that's why we have these different pieces of the antitrust pie. Mergers can catch some things. To your point, Clark, maybe the revitalization of sort of nascent theories of harm has been a push. push, including a push by Hempel recently. And so maybe that can help to avoid some of these situations in the future. But you can't see forever into the future, and we can't expect antitrust agencies to do that. So they did the best with what they had at the time.
Yeah, I would say, if we learn lessons for the next time, and so the next merger can be scrutinized with the correct analytical tools at our fingertips. But with respect to Meta and what's happening with Instagram and Facebook within Meta, well, then we just flip into Section 2. If there's a Section 2 claim, if it's a monopolization or attempt monopolization, well, we have the tools to analyze that within a single firm. It's single firm conduct. It's no longer a merger. Years after the merger has happened. That's all.
Well, we're just about out of time. I want to thank the panelists, all of you, for being here, as well as the participants online. I think if we were to wrap this with a bow tie, it would be that it's pretty hard to predict the future, and antitrust nonetheless is the law, and that's sort of the job of applying antitrust, but it's very difficult, including with respect to remedies. And yeah, we could talk about this for hours more, but you all probably have things to do, so I won't hold you any longer, and appreciate you all, and thanks for being here.